Welcome to Team Tiggio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
All right, good morning. We're on the record in the 53rd Circuit Court for the County of Sheboygan. We are providing public access on our civil docket, both in the courtroom and also online. And we have some motions filed in Horowitz and Swackhammer v. City of Sheboygan et al. It's filed 25-9139CZ. And we have Mr. Voida here on behalf of the, we'll call them the city defendants. And we have Mr. Horowitz here in the courtroom representing himself. And there's a Kim's iPad in the meeting. I ask you to unmute and turn your video on here and confirm that this is our other plaintiff.
Good morning. Sorry.
Are you Kimberly Swackhammer?
I am.
Okay. And Ms. Swackhammer is here representing herself by Zoom video again. We have three motions filed by the plaintiffs jointly representing themselves. So as we've done in the past, I'll allow one of you to argue and then ask if the other one has anything to supplement to that. And so, Mr. Horowitz, are you, since you're in the courtroom, are you the one presenting the argument first, sir?
Yes, sir.
Okay, and Ms. Swackhammer, is that okay with you?
It is. Thank you.
Okay. All right.
Before we begin, I only have two motions. What is the third?
Oh, so I've got a motion
to amend the
complaint. I have a motion for declaratory judgment. And then there was a motion in limine to exclude post cease and desist evidence.
Was that noticed up for today? Okay.
I think it was. It's really a single page for numbered paragraph motion. I guess I could have while we're taking argument on the let me see. I have an unmarked copy that I've been using. I'll have the bailiff give that to you so you can take a look at that. It's quite brief.
Thank you, Your Honor.
All right, so why don't we first handle procedural matter, the plaintiff's motion for leave to amend the complaint. Mr. Horowitz, what would you like to tell me in support of your motion?
Thank you, Your Honor. Mark Horowitz, representing myself and my sister as co-plaintiff. You had asked for us to make clarifications, and we did file the motion to amend the complaint. We removed the defendants who are no longer party to the claim, made it simpler, filed it, and the city defendants did not oppose the motion. So we assume that it's unopposed.
Okay, Ms. Swackhammer, do you have anything you want to add to that motion?
No, sir.
And Mr. Voida, any response to the motion for leave to amend the complaint?
I have no objection to their motion to amend.
Well, I'm going to deny the motion because even if the city defendants have no objection to it, there are some real problems with the proposed new complaint that purports to then say, well, we're going to have a URL website address in the written pleading, and people are directed to go to that URL to view the documents that support that pleading. And we just can't have that be a way that matters are filed. That could cause all sorts of problems. Such a procedure would be susceptible to lots of problems, such as changes to the documentary evidence or the link expires over time. These things have to be archived so that they're records for years to come. So Mr. Horowitz, Ms. Swackhammer, that procedure is just not it's just not sustainable for a court to implement a procedure like that. So the motion for leave to amend the complaint is denied. And plus, I didn't see that there was any, they've told me that some of the allegations have been streamlined. I didn't see in the motion any description about precisely what that is. It doesn't appear that it asks for any different, there's, I guess, no prejudice to the plaintiffs in leaving their existing pleading because they're not by the amended complaint seeking some new or separate relief. So that motion is denied. The existing pleadings will remain effective. All right, and then we have a motion for declaratory judgment. Mr. Horowitz.
Thank you, Your Honor. Again, Mark Horowitz. Good morning. We sincerely appreciate the court's time. We are presenting this morning a narrowly focused question of law, whether the city's August 13, 2024 cease and desist order can remain valid when the ordinance that was based on has since been repealed and replaced without a savings clause. Your Honor, this issue came to our attention only recently as part of the ongoing effort to understand how the city's own code structure applies to this case. Once we reviewed the official city records, it became clear that this repeal fundamentally changes the legal landscape that must be brought to the court's attention. If it pleases the court, I'd like to give you two pieces of, or one folder. One to the defendant as well.
Okay, and what is this?
It's a simplified exhibits. There are 3 or 5 tabs within the booklet. The first one is the cease and desist order. The second one is the meeting minutes from the city's website.
Are these documents that have previously been filed?
The first and the fifth one are.
So hang on, the day of the motion, you're bringing me more exhibits to review?
I didn't have the exhibits.
I'm not doing that. Give them back. I'm not accepting them. And I'm not reviewing those. Are you on the pleadings that you filed? You can't file a motion and show up on the day of the motion with a folder of new stuff that the judge hasn't seen and that the other attorney hasn't seen and expect us to just absorb this and move along. Hang on.
Okay.
Let me finish. You file a motion with the matters that you want considered and you notice it for hearing. There's an important purpose for that. So that the other side has notice and an opportunity to be heard. By showing up on the day with a folder full of more exhibits, that deprives them of that opportunity to be heard. So I'm not allowing that. So go ahead and argue on what you already filed.
Your Honor, this is a matter of law. The records that I presented to you are the city's own records. They're public record. And the city had a duty to tell you about the repeal and replacement of that ordinance. It wasn't my responsibility to tell you about the repeal and replacement ordinance of which the cease and desist letter is dependent on. Chapter 120 is the ordinance that's at matter here. And it was the city's responsibility, not mine, to tell you about that. It was repealed on June 24th. It went into effect on July 18th. It was their responsibility, not mine. They should have informed you. I just found it as a course of doing proper research for this case. We cannot be held responsible for their failure. They were supposed to have told you. It was their duty.
Continue. I'm not accepting new exhibits. Continue.
Okay. So the documents that I am referring to, and the fact of the matter remains that the chapter 120 has been repealed and replaced by the city by a new law. Why this matters. The cease and desist order from August 13, 2024 relied on zoning language and restrictions that exist only in the former chapter 120, vacation home rentals. That ordinance has now been fully repealed. The new ordinance, also numbered chapter 120, but titled short-term rentals, does not contain a savings clause, preserving the actions or penalties taken under prior ordinance. In Michigan, the law is clear. When a statute or ordinance is repealed, Any enforcement or penalty under it cannot continue unless a savings clause explicitly preserves it. Without that clause, pending or ongoing enforcement actions, such as this cease and desist, are extinguished as a matter of law. The city may argue that this order is issued under Chapter 154, its zoning ordinance, but it's not supported by the record. The order refers directly to zoning restrictions that mirror language in old Chapter 120. And Chapter 154 does not provide any independent prohibition, licensing, or penalty for vacation home rentals. Chapter 154 simply defines a vacation home rental as the use of a dwelling, a residential unit, where the dwelling is rented or leased for any term less than 30 days and licensed pursuant to city ordinance. That city ordinance was Chapter 120. When Chapter 120 was repealed and the definition in 154 became an empty reference, it points to something that no longer exists. So, Your Honor, the city cannot retroactively claim a different legal foundation for the same order. The order, by its language and by law, depended entirely on Chapter 120, which no longer exists. There is no factual discovery needed to decide this. The repeal and replacement of Chapter 120 are pure questions of law, confirmed by public record. Leaving the order in place, despite the repeal, effectively sanctions continued enforcement of an ordinance that no longer exists. That would not only be contrary to law, but would also perpetuate a clear due process violation against property owners who no longer have notice of any valid ordinance restricting their rights. This court has full authority under MCR 2.605 to issue declaratory relief now to prevent ongoing harm from an invalid administrative action. Your Honor, while we stand ready to defend all of our prior substantive arguments, including due process, lack of notice, and procedural irregularities, those issues are now secondary. The repeal of Chapter 120 makes those matters unnecessary to adjudicate at this stage. The court can resolve this clearly as a matter of law by voiding the order that no longer has a legal foundation.
Well, can I ask you then, okay, two questions. Number one, even if you were to establish there was some error in the wording of a cease and desist letter to you, then that wouldn't give you a substantive right to operate vacation home rental in violation of an ordinance. Even if the cease and desist letter was not written rightly, that doesn't mean that the ordinance doesn't apply to you, right? I mean, it seems like you're focusing almost entirely on this, on some real or perceived deficiencies in the cease and desist letter, but the cease and desist letter is just informing you that you're in violation of the ordinance and should stop. But even if you were right about that letter, that wouldn't give you a substantive right to do what an ordinance doesn't let you do, would it?
Number one, the cease and desist letter is an avenue for providing due process. That due process requires that the city provide us notice, an ability to appeal the notice that they're providing to us, and a clear understanding of what exactly we violated. This is not a Scrivener's error. This is not a matter of a clerical error. In this particular case, the city is attempting to enforce a cease and desist order against a repealed ordinance. It's a matter of public record that the ordinance was repealed without a savings clause.
And then another question, what's your understanding of how this litigation fits in with your pending appeal where the briefing schedule is still ongoing? Why should I grant declaratory relief now without getting the full benefit of the briefs in the zoning appeal case?
Well, that's an administrative appeal. It's not necessary for us to determine whether or not the administrative failures of the city, which is reflected in that case, is necessary to determine whether a repealed ordinance that was repealed and replaced without a savings clause, it's public record, whether that the city and the county or the court can sanction that the city can enforce an order against a ordinance that no longer exists. Technically, that ordinance no longer exists.
Okay, so you keep talking about this repealed and replaced. Can you point to me where in your existing motion for declaratory relief, declaratory judgment, where you presented this argument, or is this a brand new argument that I'm hearing today?
I did not know about the repeal and replace until
See,
this weekend.
that's what I'm getting at. I'm not entertaining brand new arguments, brand new exhibits today. So all of that stuff about the repeal and replace, I am completely ignoring, Mr. Horowitz, because you didn't properly notice that issue up. So it's not just, you know, you're showing up today with an exhibit full of new exhibits and a brand new argument that I haven't had time to review. Mr. Voida hasn't had time to review and respond to. That's not how court works. So
I
none of
understand.
that, you would have to file a separate motion. If you have a brand new issue that you learn about the day before court, guess what? You file a separate motion. We have to do things in an orderly way like that. Otherwise, people can just show up and just start throwing things around and seeing what sticks.
Your Honor,
That's
it
not
was
how
the
we're gonna
duty
do
of
it.
the city to notify you.
You're again trying to tell me how I should run my court. And I don't care whether you think I'm running my court correctly or not. I'm telling you the way it works. And I am not going to entertain an entirely new issue presented the day of.
Okay. Let's take a look at the issues that we did present to you in the.
Very good. That is what we're here today to do.
Excuse me. The order that we received is an order that's dependent on Chapter 120. And Chapter 120, if I may, can I have 1 minute?
Sure.
Thank you. If I may, in the pleadings that the filings from the city itself, they make an argument in the beginning of their filing that says that we lost our non-conforming vested rights as a result of remodel.
Yes.
And then they later on in that same paragraph say that we lost, or that we abandoned it. Okay, they use the language rendered unlawful in their pleading, in their filing. To render something unlawful means that it had to be lawful to begin with, by definition. Therefore, the abandonment that they claim that happened in time prior to remodeling could not possibly have caused the loss, because they said it rendered it unlawful. The act of remodeling rendered it unlawful. By definition, that is a fact based on their own legal admitted pleading or filing. Second,
So can I ask you then, that seems to be a major issue in this case, is whether there was a renovation that was done improperly that would have rendered, if there was a prior non-conforming use, it would have rendered that no longer appropriate. Isn't that a factual dispute between you and the city? The city says this was an improper remodel, and you're saying, no, it wasn't. So don't I have to allow discovery to proceed on that factual question?
first of all, based on our motion of limine, they never noticed us of any kind of claim that we had the remodel caused a non-conforming rights loss. That was required. If they believed that was the case of what caused our non-conforming rights loss, they were required to notice us that in the cease and desist order. They did not. All they say in the cease and desist order is you are not zoned in the proper zone.
Right, but see, that doesn't matter. But like the cease and desist letter does not like lock in every argument the city can ever present, and that's it. In the same way that, so for today, for example, today you want to talk to me about this repeal and replace of the ordinance. And I'm not hearing that today because you haven't properly noticed it up. However, you're not prevented from raising that issue to me because you didn't put it in your initial complaint. You know, you can present some arguments here. You just have to properly notice them up. And so the cease and desist letter does not like lock in the city to the only arguments they can present when they're sued. They can defend the lawsuit. So they're defending the lawsuit by saying this was not a prior lawful non-conforming use because of the unpermitted structural renovation. Isn't that a factual dispute between you and the city?
Well, it's not a factual dispute that is necessary for us to make a decision about this order, because number one, the order must have proper notice of what we violated. That's a matter of law. That the
So
order.
are you trying to tell me the only thing that you're trying to win in this case is for me to invalidate a cease and desist letter? Couldn't they just write you a new one tomorrow with different reasons?
They could write a new one based on the ordinance that is in effect. The other one has been repealed and replaced, and their own filings show that that we did actively operate a vacation home rental prior to the ordinance going into effect. The ordinance didn't go into effect until July 18th. Their own filings and Exhibit MM, which is the city's incident report, indicates that we operated a vacation home rental or a short-term rental in July of 2024, up until the point that their cease and desist order stopped us from operating the vacation home rental.
If the city was correct factually about the expansion of the residence, then they'd be right legally that would have negated your prior non-conforming use, right?
That happened prior to the operating of the vacation home rental that they freely admit happened from July 1st to August, past August, till the cease and desist letter happened.
Okay.
So they would not be right.
All right. Anything else that I need to know to understand your argument, sir?
Yes, sir. So the abandonment, as I said it earlier, because their legal admission says that it was the remodeling that caused us to lose a vested non-conforming right, which is a constitutional right that they're asking you to say was extinguished. Because they don't say that it's pending extinguishing. They say it was extinguished, meaning it's unlawful, meaning something had decided that it was unlawful. There was no administrative action that decided it was unlawful. They determined it was unlawful in a vacuum. That's what their pleading says. That never happened. So to say that it happened is improper. At best.
You keep saying that they're arguing the abandonment in this pleading. What page are you looking at for that?
In the same paragraph.
Where they say prior to this, there was no short-term rental usage of the property for at least 3 years in succession?
That's correct.
Okay. Well, is that true as a factual matter?
Is it a factual matter of that there was no short-term rental?
Yeah.
Yes.
Okay. Well, I mean, wouldn't that mean the city would win?
No, because abandonment requires two things. Abandonment requires the cease of the activity plus affirmative intent. And no affirmative intent has either been provided or has even been discussed by the city. They have not provided any intent of abandonment. Ceasing an activity, particularly an activity that is protected by 1301E, which protects properties that are in chapter 154, protects properties that are seasonally used, is not something that's allowed without affirmative intent. There is no affirmative intent. And
so typically to grant, you're wanting to kind of skip the whole litigation process and have me just rule that you win today.
No.
Because well, yes, you are, right?
No, sir, I'm not. I'm only seeking you to avoid the cease and desist order. The rest of the matters remain the same. We still have an action related to constitutional violations.
Well, on the one claim that you're presenting, you're wanting to skip the whole litigation process for that. The litigation process, we're still in the midst of discovery. And then at the end of that, there would be a trial. And then at that, then once we've completed the litigation process, and then there's a trial where all the exhibits and evidence are presented to me, then I make the rulings. You're wanting to skip all that and say you win on this issue today, And the only way that I'm allowed to do that is if there's no conceivable way that the city could develop some facts that would defeat your claim. And it seems to me this factual question about the structural expansion or remodeling of the residence would be a factual question that would need to be sorted out during the litigation process. Why would that not be?
Because the Hughes doctrine, which prevents post hoc rationalizations of the cease and desist order, is a clear established law in the state of Michigan. The Department of Transportation versus Hughes established that post hoc rationalizations, which this clearly represents, a post hoc rationalization of the cease and desist order, which is an administrative action that took adverse effects against our property, a vested non-conforming right that they clearly established existed, prevents the city and from making post hoc rationalizations of an order that they took. They were duty bound to tell us what the rationalization was for their extinguishing our constitutionally vested non-conforming rights. It's not a simple matter, sir. They're taking away our property rights without administrative action. They even say in their pleading, Your Honor, they say that the ZBA, which is a clear venue for addressing non-conforming usage, was not the proper venue for that in their own pleading, which is established in section 14 of chapter 154. So that is factually incorrect. They continue to violate our due process rights over and over again. And now we're sanctioning them to continue doing that.
Okay, thank you. Mr. Voida, your response? Or I'm sorry, hang on. Ms. Swackhammer, do you have anything that you want to add to your motion on that for declaratory judgment?
No, sir.
Okay, Mr. Voida, or city's response?
Yes, Your Honor. I think we would largely adopt a lot of the line of questioning you were asking, because the city is permitted to defend its case. It's permitted to raise issues and argue in the alternative. Our position is that at one time, this property had a lawful non-conforming use. Historically, there was a use of a vacation home rental. Our position is that it was abandoned. I learned today that Mr. Horowitz agrees that there was a period of time where it wasn't used for that purpose. There is, I suppose, a question remaining whether there was an intent to abandon that non-conforming use for several years. That's what the discovery process is for. If for some reason the court were to find that the use had not been abandoned, our position is that the construction that they did rendered it non-conforming at that point. The point of today's hearing is a motion for declaratory judgment, wherein they seek to have the court declare, first off, that the cease and desist letter is invalid. Secondly, that it is a lawful non-conforming use, and to award costs. They're essentially asking for summary disposition, even though that doesn't come up until somewhere in their reply or supplemental reply. And you've noted, Judge, I think that there are many genuine issues of material fact that render this motion premature at this stage. And essentially, the plaintiffs are asking you to take their word for it, when on a motion for summary disposition, you have to consider things in a light most favorable to the non-moving party. Looking at the exhibits that they've listed, and I've noted those in our brief, we have unverified transcripts. We have MLS listings that don't say what plaintiffs necessarily claim they say. Each listing talks about the property as a single family category home. And a guest suite or a mother-in-law suite does not render a home a duplex. I guess, Judge, we would stand on our pleadings. We would ask that you deny the motion.
Can I ask you one question?
Yeah.
Mr. Horowitz is arguing that your clients send this letter stop what you're doing, a cease and desist letter, and tell them, here's the reasons why you can't do what you're doing. And that then now, you're coming into court and your clients are giving entirely different reasons why they should not be able to do what they're doing. And why is that not improper?
It starts a process, Judge. The letter comes out, it says, look, you're in this district. This district doesn't allow what you're doing. This is a notice to you that you're violating the ordinance. Mr. Horowitz says, wait a second, we're lawful non-conforming. And we say, and I mean, this is in the form of ZBA hearings, planning commission meetings, city council meetings. We say, no, this is, we supplement at that point. And he has an opportunity to present to all of those bodies. And so the letter wasn't the end of the process, it was the start of the process.
All right, thank you. Mr. Horowitz, your any rebuttal argument on that?
That's a clear violation of the Hughes doctrine, sir. The city is not entitled to fish for a reason to take an administrative action. That's exactly what the Hughes doctrine prevents the city from doing. So what the council is doing is telling you, hey, we can make an order, take an order, and then fish for a reason. And quite frankly, their pleading says that they weren't even the proper venue to address the non-conforming use. It says it in their own pleading. So they didn't address the non-conforming use. They're asking you to address something that they should have handled administratively. And quite frankly, the Hughes doctrine is quite clear that they cannot fish for a rationale. And he just stood up and told you that they're fishing for a rationale. It's not the start of a process. It requires clear notice of a violation, the ability to appeal. Their cease and desist order does none of those things. It doesn't even give us instructions on how to appeal the decision. It's void of that requirement as well. So to say in court that it is the start of a process that is a fishing expedition, that is the very definition of that's protected by the Hughes doctrine.
Completely disagree, Your Honor.
Well, hang on. He made an argument, you made a response, and he made a reply. So okay. I think we're done with that. Ms. Swackhammer, anything you wanted to add to that, representing yourself?
No, sir.
And I'm just double checking the Hughes v. Alameda Township case. Took me a bit to find it because the citation in the plaintiff's brief was incorrect. It must have had a typographical error. Talks about a ZBA's decision to uphold the denial of a site plan.
It's Michigan Department of Transportation versus Hughes. I'm sorry, sir.
Well, you had cited this Hughes v. Alameda Township.
It's Michigan Department of Transportation versus Hughes.
What's the site for that? Was that in your brief?
I believe so. Let's see that one.
Okay, so in the Hughes case, I saw it was Hughes v. Alameda Township. With
Yeah,
the
I did
wrong
see that.
citation. That might be in the 403 motion.
No. The only cases, I'm sorry, he cites again Hughes v. Alameda Township, a case called Matthews v. Eldridge, and Zhu v. Gay.
All right. So, Mr. Swackhammer, what's your citation for this Department of Transportation case. Because the only Hughes case I'm seeing in your brief doesn't.
It's 443, Michigan 191. It's 1993. Michigan 191.
Mich 191. Is not a citation of a case.
Yeah.
It's in the middle of Cammer asphalt paving the East China Township schools. All right, the plaintiffs want this court to enter declaratory judgment. There are factual questions that would prevent that at this stage. It's premature to do that. Discovery is ongoing. So for that reason, this is essentially a motion for summary disposition before the close of discovery. There are factual questions in particular about the use of the property during the time that the plaintiffs claim it was a valid non-conforming use, how the property was used during that time, the extent of its use, and whether there were any actions taken by the plaintiffs that would have negated their status as non-conforming use are all fair issues in the litigation of this case, and they are ongoing factual development of those issues. So granting declaratory relief would be premature. That motion is also denied. And Mr. Horwitz, Ms. Swackhammer, you also have a motion to exclude evidence under 403. Go ahead with that.
Well, it uses the same principles, Your Honor. So if you don't agree with what we've already presented, it's not necessary to address that. We will address that in a separate motion.
All right, Ms. Swackhammer, anything to add on that?
No, sir.
Okay, that motion is also denied, and it seems that in reviewing that motion, which was rather brief, seems to misunderstand the rule of evidence. MRE 403 is a balancing test regarding the relevance and prejudicial effect of specific evidence. And in that motion, without really citing which specific evidence they seek to exclude, they're wanting to say that any evidence or argument generated after the cease and desist letter would be manufactured in bad faith and on an ad hoc basis without giving them any notice at all. The plaintiffs will, of course, receive notice and an opportunity to be heard regarding any arguments that the city makes in this case. So that motion is also denied. Mr. Voida, as the prevailing party, would you submit an order?
I will, Your Honor. We'll get that done.
Okay, thank you.
Thank you, Your Honor.
Thank you.